And we are live. Welcome to Crypto Law TV. I am John Deaton, the founder, and I'm your host, at least for today. And I say that because we're going to try to get other perspectives moving forward. I think we're going to have an exciting year on crypto law. Just stay tuned. I think there's some exciting things, and we're going to get more than just John Deaton's perspective on some things. Before I get into the Ripple update, let me remind you all, please take 30 seconds of your time to go to cryptolaw.us, go to the Connect to Congress tab. It's already filled out, takes 30 seconds, and the message will be to send the subpoena, issue the subpoena. Chairman McHenry, you have warned the SEC. You have written multiple letters. Gary Gensler refuses to engage in oversight. That is the Financial Services Committee. We know that the Banking Committee, chaired by Sherrod Brown and Elizabeth Warren and Jack Reed, they're not going to do it. They're not going to hold Gary Gensler accountable. So somebody has to do it. So enough with the nice letters, the mean letters. Just issue the subpoena, please, and let's actually engage in oversight. Let's hold these unelected bureaucrats who have all kinds of conflicts of interest. Let's make sure they're doing the people's work as they're supposed to. Okay. Now, we haven't had an update on the Ripple case in a long time, and that's because XRP holders achieved what we wanted as far as legal clarity. XRP in and of itself was deemed not a security, something that I guaranteed the judge was going to do. That's how confident I was, and she did it. And she ruled that when you and I go on Coinbase or Kraken or any other exchange and we purchase XRP, we are not purchasing an unregistered security. Okay, so that's why I sort of went in silent mode, because I don't represent Ripple, never have, represent XRP holders. And so, but I think it's important as we see more activity going on in the Remedies stage. Now, what's happening? There's been some legal documents that have been filed, and the SEC has filed a motion to compel, and Ripple has responded to it. And really, what's going on here? And that's all I'm going to do is explain that to you. The SEC is seeking financial statements from Ripple from 2022 to 2023. They're seeking post-complaint. Remember, when they filed the complaint, it was December 22nd of 2000, and the complaint alleged that sales of XRP were illegal securities. Well, what they're seeking now is they want all of the money that Ripple has received since that date, and they want all of their financial statements. What they're looking for is that the judge found that sales to institutions, the ones that have written contracts, that those sales constituted a sale of a security, and they were violated Section 5, okay, of the Securities Act of 1934, unless Ripple can show an exception. Now, an exception is when you're selling to sophisticated investors, accredited investors. So it is quite possible that Ripple will be able to show an exemption to the vast majority of those institutional sales. And remember what I said, it's quite possible because we won on the exchange sales. And also, by the way, I should comment that the executives' personal sales, Brad Garlinghouse's sales, and Chris Larson's sales of XRP were also deemed not to be sales of securities. And so when all is said and done, it is quite possible that the judge could find Ripple something like $10 million. It could be 10 million. It could be 100 million. I don't know. And I'm not going to guess, but it is possible if Ripple's able to show, look, judge, we didn't need to register the sale of this XRP because it meets this exception. Then we don't know what the universe is. And so that's the SEC's biggest fear. Imagine this. Imagine Brad Garlinghouse, the CEO of Ripple, has spent $200 million litigating this case and defending this case. And when all said and done, the judge issues a fine of 10 million, 15 million, something like that, or even half, 100 million. But I believe it's going to be less, significantly less than what they spent in legal fees. And the SEC thinks that too, or they fear it. And that's why they're going all out and wanting to know all the other sales and transactions. So that's what they're seeking. Ripple has responded and said, listen, what you're doing is basically amending the complaint without amending the complaint. You're adding all these other transactions after the complaint. That's really a separate trial or mini trials is the way they describe it in their legal documents. And judge, this is inappropriate. And it's really allowing them to extend their allegations without formally doing it. And discovery has already ended. And we can't engage in another year and a half of prolonged discovery. They call it a slippery slope. And I agree with them. And so the SEC flat out comes out and says they don't want Ripple to only get a slap on the wrist. See what I'm talking about? The fear that there's going to be all of this litigation, all of this expense, and Ripple has to pay some small fine. And the SEC's argument is that they need to have this information to make sure that Ripple doesn't violate the securities laws with institutional sales moving forward. And so that's really what's happening. I believe the judge is not going to allow the SEC to extend discovery. She may allow them to have some discovery. I'm not saying that she won't do that because a lot of times judges will allow discovery, but then keep their ruling much more constrained. But ultimately, I think Ripple will end up being fined significantly less than what they paid in legal fees. And what the judge is doing, remember everybody, this is a non-fraud case. The goal here isn't to punish Ripple, not under the law. It is to hold them accountable for not complying with 1934 securities laws. But, the judge is very aware of the SEC's lack of clarity and everything that has transpired. I mean, think about the Hinman speech and the fact that the SEC still won't say ETH isn't a security, even though Bill Hinman said that in 2018. And then what is or isn't, and all the confusion. Think of the Hinman emails where the SEC talked about, their own general counsel talked about how crypto fell within a regulatory gap, and how Gensler testified before he became the political operative that he is today. And he was being more sincere coming from MIT, having taught classes on blockchain and crypto, where he was honest. Probably the only time I could say in his tenure that he has been honest. And he said, look, crypto and these exchange transactions, these asset sales, he didn't call it that, but these sales on Coinbase and whatnot, they fall outside the regulatory purview of the CFTC and also the SEC. He, in essence, talked about the same thing that the Hinman emails talked about, this regulatory gap that crypto and blockchain is falling into. And that makes perfect sense. We're talking about a law that was enacted pre-internet. A law that was enacted in 1934 in a Supreme Court case that defined what an investment contract is in 1946. And so we're taking a 1946 articulated test and we're trying to apply it to modern day blockchain technology or modern day artificial intelligence or any of the other technologies that come forward. And it's difficult. So the SEC was right in those emails talking about this regulatory gap. And Gensler was right when he said that these exchange transactions fall outside the jurisdiction of the SEC. And so the point I'm making is I think that Judge Torres is very aware of all of this stuff. And so when you sit back, is she really going to punish Ripple and say, oh, even though the FinCEN settlement happened in 2015 and you didn't have to comply with securities laws, and although a year before that, the Government Accountability Office described XRP as a virtual currency utilized in a decentralized payment protocol called Ripple. That happened in 2014, then FinCEN a year later, and then the Hinman speech 3 years later. And then in 2019, Coinbase goes to the SEC and says, we're going to list XRP unless you tell us you think it violates the securities laws, and they don't. And so they list it. And then that same year, Ripple buys 9% of MoneyGram, and they file with the SEC a form saying MoneyGram is going to utilize XRP in its cross-border payments. And nothing is said or done by the SEC. All of this is happening for 7.5 years. So do you think Judge Torres is going to sit back and be like, damn, I got to punish those people at Ripple? I don't think so. And I think the SEC doesn't think so. And that's why they write in their briefs, they want to avoid a slap on the wrist that will encourage Ripple to further violate the laws moving forward with their institutional sales. That's really what's play here. The one thing I can say, and what's this mean for XRP? It means that I don't think there's any talks of settlement. And I've said that for a long time now. They're just not. This is still scorched earth litigation, even in the Remedies stage. I don't believe there is. That doesn't mean it won't happen. That doesn't mean that it can't be a phone call and come together rather quickly. It doesn't matter that if there's a ruling from this judge and the SEC thinks that they can get more from Ripple in a settlement than she might rule. Maybe that'll make them come to the table because then they can spin it versus getting another ruling that embarrasses them as an organization. So I'm not saying settlement can't happen or won't happen. I'm just saying, updating you all, that it's not happening today, as far as I know, and this litigation sort of proves that. So there's not going to be any settlement news, I don't believe, in the very near future. Now, XRP holders, what's it mean as far as our amicus brief? Well, we don't have a lot of role in the remedies section. Now, remember, in the remedies section for library, I did go in as amicus counsel for Naomi Brockwell because there was that discussion about secondary sales. And Judge Torres cited my discussion with the judge in library in her footnote in the Ripple decision, where the judge agreed with me that his ruling didn't apply to secondary market transactions of LBC tokens. And so, but in this case, you don't see me moving in and trying to participate because this is really all about Ripple and these institutional sales. Had the judge ruled otherwise and called our transactions of XRP illegal securities, then of course I would have been much more vocal at this stage. But we got what we intended. And so we're just sort of waiting it out. Now, what happens after this? A big question is, does the remedies impact XRP? A lot of people talk about price. I don't know. If there's a settlement, will XRP go up? Your guess is as good as mine. If Ripple were fined a big number, could it obviously have a negative impact on XRP? That's possible. If you ask me what I think is going to happen, I think there's going to be a decision by the judge, and I don't think it's going to have a huge impact either way on XRP. I'll come on air and I'll say I was wrong if I'm proven wrong, but that's what I believe. But not to take any kind of financial advice from me. I'm the last person to ever do that for. Okay. And I can prove it by showing you my accounts. Now, if there's an appeal, if there isn't a settlement between the parties, then there will be an appeal. And that appeal will be to the next court, which is the Second Circuit Court of Appeals. And the question is, well, will we be amicus in that court? And the answer is yes. We were amicus in the district court level. And so if the SEC appeals the decision, they're not going to appeal whether XRP itself is a security. They've already said that. But if they're going to say that the judge was wrong and that when you and I go on Coinbase and we purchase XRP, that those are securities, then of course I'm going to file an amicus brief. Of course, I'm going to ask the appellate court to look at the affidavits that we submitted that were cited by Judge Torres. And of course, we are going to participate because obviously it's conceivable, not conceivable, but possible that the Second Circuit could overturn Judge Torres. I don't believe they will. I think her decision is so fact specific and intensive to the Ripple case that the Second Circuit won't overturn it. But remember this, the Judge Torres, a lot of people always forget this when they talk about an appeal. Judge Torres did not analyze the first factor of the Howey test and did not analyze the second factor of the Howey test, the common enterprise factor. She went straight to the third factor, which is whether or not XRP holders had a reasonable expectation of profits derived from the efforts of Ripple or others, okay? And she said that when you and I buy it on an exchange, that third factor has not been met. So even if, and I believe that the second prong was stronger for us, just so you know. So even if the Second Circuit were to say, Judge Torres, you got it wrong, it doesn't mean Ripple loses. It just means that they send it back to Judge Torres and she finishes her analysis. And she very well could say that there was no common enterprise and then rule in our favor again, even after a successful appeal by the SEC. All right. Because remember, they have no expert witness. It was excluded on the common enterprise. And so all they can prove is common interest, that you and I as an XRP holder have a common interest with Ripple, who also owns XRP. Well, common interest cannot be equated to common enterprise. And there is no horizontal commonality under Second Circuit law, in my opinion. So the SEC will ultimately lose again. That's why I was so confident. I got a little bit in the weeds there, but I wanted to remind people that the appellate process wouldn't even end this case that way. Now, the Second Circuit affirms her decision, which I believe it will. And then, you know, the SEC is certainly not going to appeal it to the Supreme Court. Now, that's really where we are. The last thing a lot of people ask is about the class action. Remember, the class action against the SEC was to get the regulatory clarity. It wasn't a suit for damages. I've explained that many, many times to people. I've explained to everyone, why do we fight so hard for an investigation? Because we have overwhelming circumstantial evidence. We know that there were conflicts of interest. We know that there were secret meetings. We know all of that information. There is a strong case of capture related to a small group of people, including ex-regulators. But you have to have something that's going to get you over a motion to dismiss. And so what we need is the investigation to happen. And once we uncover something more, we will be able to maybe get over the hurdles of qualified immunity. All right. Remember, a government actor, like a cop, if they arrest you and they're wrong on probable cause, you can't sue the cop individually for being wrong. Now, if you can prove that the cop intentionally, arrested you and planted evidence and do all that kind of stuff, then of course you've got a case. And so we're still pleading for that investigation, because I do believe that there is a case for regulatory capture that is viable. But please know that the day that that case gets filed, you're going to have the biggest, most expensive lawyers in the world, and along with the U.S. government coming down, trying to get that case dismissed immediately. So go to connect to Congress, get the invest subpoena to the SEC, keep pushing for an investigation, and then we can pursue what I believe is a very viable case. A lot of people disagree with me, but they disagree with me about a lot of things. And we know how that turned out. Now, with that said, that's really it for this week. Like I said, there's going to be exciting news coming to crypto law. I'm going to be reaching out to some very talented people, smarter than me, that have different perspectives than me. Crypto law isn't just about one man's perspective, okay, or one woman's perspective. It is about producing to you all content of what's important about crypto and blockchain technology as it intersects with regulation and the law and the courts. And I'm very excited about what's going to happen in the future. With that said, I will see you soon. God bless everyone. Have a good week.